If you're an adult of any age, you have specific risks and responsibilities related to your health. If you got sick or injured and became brain dead, do you want to be kept alive indefinitely? If you're injured or incapacitated, who will collect your income, access your accounts, and pay your bills until you recover? If you have children, who will raise them if you die? Do you have this documented? The last thing you want is your family arguing over who should raise your kids and where, only to have a judge make the ultimate decision. A basic financial rule is that you always insure against large risk. A little bit of documentation is the most and sometimes only way to insure against these and other big risks. This presentation is focused on the basic blocking and tackling involved in structuring your estate plan, organizing information to simplify implementation, and making you comfortable that you have your stuff together. Hopefully you've had a chance to watch the income planning series because managing your income for tax and timing prioritization is a big part of reducing overall post-death taxation. If you've not seen it, make a note to watch it after you've gone through this. Okay, start by creating a paper or secure electronic file that holds all of your life, disability, or long-term care insurance policies, a statement from each account holding investments, a contact information for tax, financial advisors, attorneys, insurance professionals, and HR departments, and bank numbers, names, phone numbers, etc. This file will also hold a copy of your planning documents, your wills, trusts, powers of attorney, and healthcare directives. Tell your personal representative and one or more children or a close friend where this file is located. Revisit this file every couple of years to help you keep it up to date. Okay, let's begin with healthcare directives. These dictate what decisions are to be made under certain dire health circumstances, and who is authorized to communicate these wishes and directives to the doctors involved in your care. It makes sense that anyone over the age of 18 complete one of these because the parent's authority has otherwise lapsed, and doctors have no choice but to do any and all things to keep you alive, even if you would prefer them not to. You can find these documents online or at any hospital. It just takes a couple minutes to fill them out. Everyone who's over 18 and has debt or bills should complete a power of attorney. In Minnesota, the standard is the Minnesota statutory short form power of attorney. You go online, you type that in, you'll get a copy of this document. This allows someone to communicate with your creditors, pay your bills, speak with your employer and others in the event that you become disabled or ill to the extent that you cannot handle your normal tasks. If you do not do this, someone may have to go to court to be appointed in some capacity to help you, which of course takes a lot of time and a lot of effort. The document provides a power that springs into being upon specific events. You're not blanket giving someone access to your stuff unless you are seriously messed up. Wills are needed when people have minor children or assets that will not transfer through beneficiary designations. If you have children, the most important thing a will does is designate guardians for your children. You do not want interfamily arguments about who raises the kids and where, and no, godparents are not guardians. For some reason, people have a tendency to think that godparents are guardians. I don't understand it. If you do not have children, but you do own a car of value, a house, or other assets, a will identifies the personal representative. This is also very important. This, again, is the person who pays your bills, closes your accounts, files final tax returns, and funding accounts based on provisions written by you if you have a will, or a court if you do not have a will. A will by its nature needs to be probated, which is simply a legal process that finalizes your affairs. People are generally afraid of it, but most of the time it's not a big deal. Most small estates will be allowed to do what's called a de minimis probate via the mail, often without even needing an attorney, which avoids a costly court process. Even if your will does little more than identifying the person who is your personal representative, it's worth the effort. If you die without a will, the court decides who your personal representative is and who your beneficiaries are and how they are treated relative to you and each other. Even if you're married, assets that are not subject to a beneficiary designation will be divided 50% for your spouse and 50% split by your children. This can create its own mess. Assets transfer either by contract or by will. IRAs, insurance policies, annuities, and 401k type plans pass by contract, where you identify a beneficiary. For the most part, everything else will pass by will. If you own a home jointly, the survivor automatically owns the home when the first person dies. This should give you a good start in organizing your estate plan. Future presentations will go into more detail as to how to make gifts to your kids and control estate taxation for those people that have those concerns. If you have any